In the name of God, the compassionate, the merciful, welcome, friends, to the 56th episode of Crime and Punishment, a legal podcast, not a political one. The official podcast of the Invictus Law Firm, PA, a criminal defense law firm in Orlando, Florida, the website for which is Augustusinvictus.com. And that is me, yours truly, the host of this program, which program we are simulcasting to Twitch, DLive, Twitter, YouTube, LinkedIn, Facebook, I think, possibly something else, I don't know. But you check in the description, you can subscribe to all those things. You're going to have to go to Twitter, which is twitter.com/EmperorInvictus, in order to subscribe to the newsletter, because I, again, did not post that link in the description. But you can do all that at your leisure. We'll publish the newsletter again soon, I'm sure. Today, we've got a lot of legal news. Ulfric, first comment of the day. King of the Hill, welcome. Good afternoon to you as well. Cool plans this week. Oof. You don't even want to know. Went to Muay Thai earlier today. Got Jiu-Jitsu tonight. Probably going to be nursing something broken by tonight, so those are my plans. And good afternoon, Padfa. So, let's get into this legal news. We got a lot to talk about. If I can find the window here. You'll perhaps remember that quote by Rage Against the Machine and Bulls on Parade. They don't gotta burn the books, they just remove them. Texas ISD pulls Bible from schools, announces sweeping book removals after months-long review process. So apparently a bunch of parents, presumably Marxist parents, who probably adopted their children in some travesty, complained to the school that there were all these books that dealt with offensive topics. So they opened an investigation, and finally, ultimately they said, yeah, well, let's just pull everything that was complained about. And so the Bible is the most outrageous of that list, but I can't find the list itself. But that's the thing, right? We don't have book burnings in America. We have quiet removals of books from the shelves. We don't ban books in America. You can buy them on Amazon, but you certainly can't talk about them in school. You don't have, public executions anymore. Maybe you've got the occasional, well, this guy's going to the electric chair and you can show up in person, but we don't do public hangings. We certainly don't do gladiatorial fights. God forbid we give the man the means to defend himself in this fight to the death. Instead, we civilized modern Americans, or modern Westerners, if you will, we just imprison you for life. You go to prison to live in hell for the rest of your life. We don't give you the dignity of dying. So we don't have to burn books. We don't have to give you a dignified death. We just remove books. We just let you live forever in hell. These are the humane things to do. No violence. Not burning anything. Not putting anyone to death. There's no violence behind this. That means it's okay. We've also got a story about how the rosary became an extremist symbol. Got an article here about ex-judges being ordered to pay more than $200 million to the victims of a juvenile detention corruption scheme in federal court. The case was in federal court. Their cases, the judges, though they were state court judges. In any event, we'll talk about that. We've also got something my son said, you know what, I can't say that on air. He asked me to play this for you. It's a video about the DOJ resisting the unsealing of the search affidavit in the Trump case. Amazing, amazing find, my son. Because on August 12th, a week earlier than today, right? Last program, I talked about the DOJ and Attorney General Merrick Garland going all over the media. We are committed to full transparency, and these conspiracy theorists this, and this guy shot up the Ohio FBI office that, and these J6ers and Trumpers and insurrectionists this and that. We need to unseal the search warrant, and we need to unseal all the property it was taken from Trump's home, so that these conspiracy theorists and lunatics will be silenced once and for all. Full transparency. This video, which was published on Monday, the 15th, after this media blitz by Attorney General Garland, talks about how the DOJ has now done a 180, saying, well, but you can't unseal the affidavit that we used to procure the search warrant. So let's come back to that. We'll put a pin on that. Roy Moore wins his defamation case. Phenomenal. Jury awards him $8.2 million. I don't know if you remember Roy Moore running for, I think it was for Senate, right? Yeah, in Alabama. So a former judge running for Senate, United States Senate in Alabama. No. Don't you start that. Running for Senate, and these people did what they do to everybody. They came out with false allegations against him by women who said he did bad things, right? Story older than Beauty and the Beast. He won. He sued for defamation. It has been years. I mean, what was this, a 2016 election? This was forever ago. And he just won the defamation case, $8.2 million. And of course, the usual suspects in the mainstream media are saying, oh, well, this will be overturned on appeal, and here's this expert and this fact checker, and this is going to be appealed, so on and so forth. The guy won $8.2 million for a defamation case against the Democratic PAC. Amazing. Minneapolis schools will lay off white teachers first. That's a headline. But is it even surprising? We're probably not even going to get to that article. It's so not shocking. And then a really interesting article. Not really an article, it's an actual opinion by the Supreme Court of North Carolina. Full disclosure, I'm not a North Carolina attorney. And one disclaimer I should probably make in every episode is none of this is legal advice. You should talk to your lawyer before acting on anything you hear in this wild program about legal news. This is purely for entertainment purposes. So if I talk about an opinion from the Supreme Court of North Carolina, I'm not talking about it as a North Carolina lawyer. I'm just talking about it as a guy on the internet who talks about stuff like everyone else you listen to. The only difference is I happen to have a law degree and a bunch of licenses. So my opinion is probably worth more, but I'm not a licensed attorney in North Carolina. So it's a layman's opinion. But here's what it's about. Racially gerrymandered North Carolina General Assembly as an unconstitutionally constituted legislature did not have the power to propose amendments to the North Carolina Constitution. Amazing. I love this opinion. So let me translate that legalese. This group of people who, that's not where my mind went. My mind went a lot further back, but we're talking about 2018. These people apparently, and I mean these people, the politicians in North Carolina, apparently gerrymandered the districts there to do the usual thing the white supremacists do, disenfranchise minority voters. Well, they were caught red-handed. The Supreme Court said, no, you can't do that. And because you did this, your General Assembly, your legislature, it's unconstitutionally constituted. So no, you've got to go back, redraw those districts, and give these people the right to vote because you took it away from them, right? So now, years later, they come back and say, hold on, we told you that you were an unconstitutionally composed legislature, and what did you do? you went at the very last minute and passed a bunch of laws. Knowing that you were an illegal group, you passed a bunch of laws. So all of those laws that you passed, you didn't have the power to do that. And you didn't have the power to propose amendments to the North Carolina Constitution. So they're all void. All of those laws are void. Phenomenal. I couldn't be more excited about this opinion, and let me tell you why. It's not because some 2015 or 2018 legislature did some gerrymandering and passed some voter ID law. I don't care about that. What's fascinating about this is the logical consequence at the end of that road. If the founding fathers were all actual white supremacists, right, who actually owned slaves, disenfranchised anyone who is not a white Protestant male, isn't everything that we've ever done in American law illegal? Shouldn't it all be overturned? Shouldn't the entire thing be burned to the ground if that was completely unconstitutional? And let's say, okay, the 13th and 14th Amendments weren't passed yet in 1789 or whenever. At least from the Reconstruction era, right? Let's say 1870, just throw a dart at the board here on the timeline. Shouldn't every legislature past 1870, all of their laws be voided? They were trying their best to disenfranchise all minorities and women until, like, I think 1924, if I remember correctly. 1920s, anyway, that women got the right to vote. Shouldn't everything at least from 1870 to 1920, any laws passed then, be voided? Jim Crow era. Yeah, we've got a lot of unconstitutional things, but if those legislatures were illegally composed, if those legislatures themselves were illegal, unconstitutional, because they had excluded black voters, shouldn't all of those laws be voided? Every Southern legislature before, like, 1970, shouldn't we just throw out all of those laws? And by the way, all of the court cases that set precedent, shouldn't we void all of those as well? All the Supreme Court opinions, which were by all white male judges, panels, shouldn't we throw out all of those opinions too, so that everything before, like, not just 1970, 2022, shouldn't everything before this year be completely thrown out? All judicial opinions, all Supreme Court opinions, all laws passed by every state legislature and the federal legislature, they should all be void by this logic. We live in such exciting times. This was posted, by the way, by Anthony Michael Crace, a law professor and political scientist at Georgia State Law. I don't know who he is. This came up in my Twitter feed after I'd already posted everything for today's show. And I went and read this opinion. So I guess we're starting with this, right? Because we're 15 minutes into the program. We're done doing the opening. So I went and I looked at the opinion itself when I saw this, waiting for the program to go live. This case involves completely unprecedented circumstances that give rise to a novel legal issue directly implicating two fundamental principles upon which North Carolina's constitutional system of government is predicated: the principles of popular sovereignty and democratic self-rule. If there were two phrases that everything in domestic and international politics has been based upon since 1916, it's that. The principles of popular sovereignty and democratic self-rule. Well, 1914. I don't know when they actually started justifying what they did in World War I with all this democratic self-rule stuff, but ultimately that's what World War I became about. These people have to be able to self-rule. democratically. We have to destroy Germany because they will not allow this to happen. They're living in the past. Popular sovereignty, democratic self-rule. That's everything. Shouldn't we throw out everything from 1914 to right now? Because the history of America and the world, it's not based upon the principles of popular sovereignty and democratic self-rule. Anyone can see that, even fascists. The issue, continues the Supreme Court of North Carolina, the issue is whether legislators elected from unconstitutionally, racially gerrymandered districts possess unreviewable authority to initiate the process of changing the North Carolina Constitution, including in ways that would allow those same legislators to entrench their own power, insulate themselves from political accountability, or discriminate against the same racial group who were excluded from the democratic process by the unconstitutionally racially gerrymandered districts. In other words, you gerrymandered this district to disenfranchise, I don't know, I'm not an expert on this case, to be honest. I don't know who they were disenfranchising. Might have been blacks, might have been Hispanics, couldn't have been women because we're co-ed, right, in this country. So who knows? Could have been blacks, could have been Hispanics, but I'll tell you, one of these sticking points is the Voter ID Act. So they're saying you disenfranchised these poor minorities, and now you're passing laws to demand that they show ID to vote. This is just insulating yourselves from political accountability. It's discriminating against the same racial group that you gerrymandered all these districts from, and now you're trying to impose voter ID laws on them so they can't vote you out. How dare you? You need to get with the program, gentlemen. You need to get on board. This is the way things are now. You don't demand ID. Everything's going to be mail-in ballots soon anyway. Why not just vote online? The easier, the better. We need universal suffrage. Let's drop the voting age to 14. Don't check ID. Do it online. You guys are living in the past with all this we have to know who's voting nonsense. In the final week of the final regular legislative session preceding the 2018 general election, a General Assembly that was composed of a substantial number of legislators elected from the districts that the United States Supreme Court had conclusively determined to have resulted from unconstitutional racial gerrymandering, enacted legislation presenting 6 constitutional amendments to North Carolina voters. Some of these measures passed in the General Assembly by notably narrow margins. Some of whom, a substantial number of legislators. What is that substantial number? They don't bother to say. Was it a majority? They probably would have said that. So we can assume it's less than 50% of these legislators proposing these amendments were from the unconstitutionally composed legislatures, or districts rather. But let's carry on. Some of these measures passed in the General Assembly by notably narrow margins. By this time, it had already been established that 28 legislative districts were drawn in a manner that violated the Equal Protection Clause of the United States Constitution, and many other districts had also been withdrawn to remedy this unconstitutional racial gerrymander. The 2 amendments at issue in this case, the Tax Cap Amendment, the Voter ID Amendment, cleared the required 3/5 supermajority threshold by 1 and 2 votes in the House and by 4 and 3 votes in the Senate, respectively. That's a razor's edge. Both amendments were ultimately ratified by a majority of North Carolina voters. In that same election, conducted using newly drawn legislative districts, the voters denied to any political party a 3/5 supermajority in either the North Carolina House or Senate. Now, that never happens. That the voting populace votes one way, and then when the wind blows, they vote another way. No, this is clearly evidence of a conspiracy by these lunatics demanding voter ID reform. What is extraordinary about these events is my favorite paragraph. What is extraordinary about these events is not that a legislative body was composed in part of legislators elected from unconstitutional districts. That has occurred on numerous occasions in recent years just in North Carolina alone. Rather, what makes this case so unique is that the General Assembly, acting with the knowledge that 28 of its districts were unconstitutionally racially gerrymandered, and that more than 2/3 of all legislative districts needed to be redrawn to achieve compliance with the Equal Protection Clause, chose to initiate the process of amending the state constitution at the last possible moment prior to the first opportunity North Carolinians had to elect representatives from presumptively constitutional legislative districts. In other words, North Carolinians were just about to vote all of you people out of office, and at the last minute you passed voter ID laws. How dare you? How dare you influence an election in such a manner? So, exciting. I hope every state starts jumping on this bandwagon. I hope we reach the logical conclusion. Let's follow this train. Oh, I love this story. Yeah, we're not going to have time for this. Minneapolis schools will lay off white teachers first. But is it stories we read about garbage like that? Let's check out the one that my son wanted to talk about. This is hilarious. Hopefully you can hear it. Uh-oh. Nobody can hear it, huh? That is unfortunate. So, let's see what's going on here. Nope. That is unfortunate. Nope, that's the wrong button. That is Dark Synth. Hold on a second here. Boy, that's unfortunate. Well, And now it's not registering. There we go. How long has this microphone been off? This is a disaster of an episode. I hear nothing now. Yeah. Oh, man, you gotta be kidding me. What a disaster of an episode. Anyway, the question here is, Invictus, what are your views on the Second Amendment? Doesn't banning ex-felons and people who at one time had substance or mental issues violate the God-given right to self-protection? And I would say yes. That is correct. As I've pointed out many times, everything is a felony now. You know, tax evasion is a felony. Having a Xanax tablet is a felony. Driving on a suspended license a couple times is a felony. I mean, you name it. Stealing like over $300 is a felony. Everything's a felony. So it used to be that the difference between a felony and everything else is that you deserve the death penalty for a felony. So what does it matter if you can vote or not? You deserve to die. That would be murder, robbery, rape, horse thievery, which, you know, back in those days meant you were taking a man's livelihood away. I think I said burglary. I said robbery, burglary, rape, murder. Anyway, these things you earned the death penalty for. So taking your right to vote, you know, if you were allowed to live, who cares? You know, you were convicted of robbery, and you lived, so of course you shouldn't be voting. Like, that's not really controversial. But when everything becomes a felony and you live in a police state, then why would we take away your right to vote? Because you were convicted of having an unprescribed Xanax tablet in your pocket. It's ridiculous. And the other one, mental health reasons. You're not allowed to have firearms because of mental health issues. Then you're just giving the interpret. It's bad enough when judges interpret the Constitution at their leisure, you know, based on whatever whim or political ideology thereof. But you're going to start giving interpretation. You're going to start giving constitutional rights, and the watchdogs are going to be psychiatrists. Get out of town. These Marxist pencil neck perverts, like that are telling kids, you know, you're not really a girl. You're a boy. You should strap on a penis. We're going to give those people the authority to say this person has mental health issues, he should not have firearms. That's insane. Then what does the Second Amendment even matter anymore when some doctor can say this guy's mentally ill, take his guns away? We're in that crossroads. We've been in that crossroads for several years now concerning the First Amendment. What does the First Amendment even matter if it's not the government that's censoring you? It's YouTube, Facebook, Twitter. These are the new public forums. Government doesn't have to lift a finger. Everybody's been pushed to these same social media platforms, and everybody's getting censored for having the wrong views, but it's not the government, so you have no First Amendment rights. So now, well, it's not the government that's saying you're mentally ill and you can't have firearms. It's the doctor. He says you're crazy, you're a harm to yourself and others. You can't have guns. So yeah, I don't agree with any of that, any of these modern trends where everything's a felony and so you can't have guns. And this person's mentally ill because he's saying crazy things, so he can't have guns. No, I disagree with all of that. Hail Invictus, still in the bricks and flotsam of Bloomington, Indiana. How's it going, Seamus? Hoosiers. Can't hear. Yeah. Yep. We're having some trouble today. Couldn't play the video. Didn't pick up on the OBS. And then microphone came unplugged. We got 7 people watching now because everybody got tired of the technical difficulties. Next week, we'll do better next week. Symphony is asking, isn't Truth Social just the latest in a series of Kushner-controlled Q-tard board? I don't know. I don't use Truth Social. Maybe I should. Maybe we up the viewership on this bad boy. Can't hear anything. Yep, sorry about that. Fixing software license issues with Mastodon. I don't know, but I love Mastodon. Crack the Sky, Leviathan. That's some good metal right there. Hey, Joe Biggs. Joe Biggs loves the shows. Thank you, Joe. Long time no see, buddy. Hope everything's going well. So, I guess we've reached the end of our... we never talked about the rosary. That was the whole... I wanted to start with that, and we ended up going backwards. I guess we read the most important things, but let's talk about this. So The Atlantic published an article that just infuriated everyone. How the rosary became an extremist symbol. The AR-15 is a sacred object among Christian nationalists. Now, radical traditional Catholics are bringing a sacrament of their own to the movement. This was published August 14th, so this was on Sunday. Violating the Sabbath, the Lord's Day, to publish this blasphemy. Daniel Paniton. Just as the AR-15 rifle has become a sacred object for Christian nationalists in general, the rosary has acquired a militaristic meaning for radical traditional or rad-trad Catholics. Let me clue you into something, Daniel. The rosary has always been militaristic. It's part of the church militant. Rad-trad, that is Catholicism. On this extremist fringe, that is actual Catholics, rosary beads have been woven into a conspiratorial politics and absolutist gun culture. Let's open this hyperlink. That sounds fun. Is the growing anti-pope rad-trad community poised to become Q-Atholics? History is an what are you hyperlinking to? What is this? Religion dispatches? What is this garbage? Whatever. I'm not even getting into that. These armed radical traditionalists have taken up a spiritual notion that the rosary can be a weapon in the fight against evil and turn it into something dangerously literal. Again, nothing new. The rosary is a weapon in the fight against evil. That's what it's always been called for hundreds and hundreds of years. But this is news to The Atlantic. Their social media pages are saturated with images of rosaries draped over firearms, warriors in prayer, Deus Vult crusader memes, and exhortations for men to rise up and become church militants. I imagine this guy does not actually know what church militant means. Influencers on platforms such as Instagram share posts referencing everyday carry and gat check that includes soldiers' battle beads, handguns, and assault rifles. One artist posts illustrations of his favorite Catholic saints, clergy, and influencers toting AR-15 style rifles labeled Sanctum Rosarium alongside violently homophobic screeds that are celebrated by social media accounts with thousands of followers. So back up there. Violently homophobic screeds. That's where it is. That's where we're coming from right here. You wonder why The Atlantic would publish something attacking radical traditionalist Catholics. How dare they make the rosary a weapon against evil like it hasn't been for the past 800 years? Well, yeah. It's anti-homosexual. The theologian and historian Massimo Fagioli has described a network of conservative Catholic bloggers and commentary organizations as a Catholic cyber militia that actively campaigns against LGBTQ acceptance in the church. These rad-trad rosary as weapon memes represent a social media diffusion of such messaging, and they work to integrate ultra-conservative Catholicism with other aspects of online far-right culture. Amazing to see the Vatican and the journalists, quote-unquote, of The Atlantic walking hand in hand on this. But I'll let you make your own decisions on that, your own conclusions. We're just reading the news here. And we will read it again next Friday, the 26th, same time, same place. Till then, everyone.